Hi, my name is Jessica Stahl. I have been teaching special education for 3 years now. After I graduated from Fort Hays State University with my bachelor's degree in education and minor in special education, I was offered a job with Sumner County Special Education. I started my first year in a high-incidence classroom teaching K through 7th grade students in South Haven, Kansas. I then transferred to Belle Plaine Elementary to become their K through 4 low-incidence teacher. So here I am completing my requirements to obtain a master's in low and high incidence special education. The case I am presenting on is Doug C. versus Hawaii. Doug C., the parent of Spencer, a 15-year-old student diagnosed with autism, sent a request to reschedule his son's annual IEP meeting because of an illness. He provided dates that would be best fit for his schedule, but they were past the annual review deadline. The school district provided dates that all members could be present and still meet the deadline. After several schedules and reschedules, the special education director of Maui High School decided to proceed with the meeting on November 9th without the parent, child, or representative from Horizon Academy, which was the current educational placement of the child. The new IEP changed Spencer's education placement from Horizon Academy to Maui High School. On December 6, 2009, Spencer's father requested a sped due process hearing against the State of Hawaii Department of Education because Spencer's November 9, 2009 meeting was held without his presence, citing violation of students' FAPA according to IDEA 2004. At the due process hearing, Doug lost his case, so he filed an appeal with the U.S. Courts of Appeal for the Ninth Circuit. The central issue in this case is whether the department's efforts to include Doug C. in the November IEP meeting are sufficient to meet the requirements of the IDEA. This case was argued and submitted October 16, 2012. However, the final decision of the U.S. Courts of Appeal, Ninth Circuit, didn't occur until June 13, 2013. The U.S. Courts of Appeals, Ninth Circuit, made their final decision. The appeal court agreed with Doug C., overturning the original ruling. It was found that the parents' opportunity to participate was obstructed by the Department of Education and that the student was denied an educational opportunity. The student's educational placement, current and further, was not put into consideration when decisions were made without parent involvement and consent. The court also requested reimbursement to the parents. This case helped answer several critical questions in regards to holding an IEP meeting without the parents. The first question answered, must the school hold an IEP meeting before the annual review deadline? If the meeting is not held, do the child services lapse until a new IEP is agreed on? Services do not lapse because of the lack of a new IEP. The next question, if there are logistical scheduling conflicts for an IEP meeting, is priority given to the schedules for the school staff or the parent? In all cases, priority is given to the parents. The next question, can the school cure the failure to include the parents at an IEP meeting by convening a second IEP meeting with the parents within 30 days? The answer is no. Parental involvement after the fact is not enough because the IDEA contemplates parental involvement in the creation process. The final question that was answered, if a school district violates the first prong of providing FAPA, compliance with legal procedures, must the reviewing court still determine if the district violated the second prong of FAPA? The answer is no. The court does not need to determine whether there was a violation of the second prong. This case mostly determined that the emphasis of parent involvement in the IEP meetings are very critical.